teachers, yeah.
Yeah.
When Kovach left teaching, well, first Don's dad left, they had those, and then Kovach came over. And they were church officers.
Hey, I don't care where you sit.
Oh, God.
I really don't care. You can sit over
Yeah,
here.
you would imagine.
What?
Kovach would, they'd go to some kid's house that was skipping school.
You know what?
Jack, Don's dad would go knock on the front door, and Kovach would go out the back. Yeah, she'd come down the front door.
Wait, let me record that.
You're so beautiful.
I just took a picture.
With my funny face.
Yeah.
John Butler, so I sent him an application. And then
Filled it out.
Oh, you did? Oh, okay. I think Marcy will be here.
Right.
Are you sure? We'll move. We'll move. Yes.
And I got, yeah, I missed it yesterday in the flood of emails.
My sister-in-law. Here.
Peterson, he's first in a long time.
I was headquarters, it must have been at the Adams.
Oh, yeah, maybe.
Yeah, I didn't stay there very long. Oh, yeah.
I will be hearing public comments.
Angie.
Oh, shoot, look how terrible he
I,
looks.
well, I texted Tina that the first thing this morning, I'm like, I have a, we have a party.
I'll be there too, so you can get my hair done at 5 and I have a nail appointment at 8 when I'll do
I'll bring
the
the wine. If you have an appointment late enough,
They don't
to bring
care.
wine.
Hey, good looking.
What happened?
You can show up if you want.
We're on.
We're on. We're on. We're recording.
Good afternoon, everyone. This is the December 2, 2022 meeting of the St. Joseph County Election Board. Let's stand for the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Next is the consideration and approval of the minutes of the November 18th, 2022 meeting of the board. We have just received those minutes fairly recently, but thank you for getting them done, Lana, appreciate that. Have we had time to look those over to see whether there are any modifications there? Seeing none, can you read a motion?
I see none, but I wasn't there, so.
I only looked at it quickly, so I don't know if you want to go on table to the next meeting, because that's pretty extensive.
They are fairly extensive. Yeah, I have not had a chance to read over them in detail yet. So let's go ahead and put this off to the next meeting then, give us a chance to read them over.
Sorry, we were working on year-end books, too.
I know, I understand how this gets to be at this time of year. All right. The next item is, the main item we're dealing with today is the issue of processing of a canceled voter request on November 7th, 2022. Issues that were raised with respect to whether the change of a voter's status from canceled to active was appropriately done. We did consider just for way of background, we did consider the question of whether the ballot itself was valid at our last meeting. And the determination, which was a unanimous vote of the board, was that for a canceled voter under Indiana law does have an absolute right to vote by coming in and doing two things. One is, the first thing, of course, is presenting oneself ready to vote on election day, and at the same time stating that the person still lives at the address at which the registration was canceled. We did not find anything in the record that showed that the voter herself did make the statement that in fact she was still at that same address. And based on that, we believe that we had to, under Indiana law, not accept that particular ballot. But this is a different issue. The hearing will not be today, but what we want to do is to go through kind of what the issues are and also hear from others with respect to a number of kind of what we call pre-hearing issues and pre-hearing determinations. So the first question is, what exactly are the concerns or the allegations that we have to deal with here? We do have some exchange of emails that go back to, I believe it was November 7th, and also some minutes that arise out of there's a meeting actually on November 7th at which this issue was brought up. But it's been exactly unclear how it was framed, and of course the person who is alleged to have made errors in this process does have a right to know exactly what it is that she is being accused of, or is that she has not done correctly. So the information I have arises out of the minutes of the meeting of November 7th, which I believe we have approved, and there was a discussion, and this is just an oral back and forth. Tom Dixon made some comments, I made some comments, and then there were some emails back and forth as well that discussed this. But I want to make sure that we have a clear understanding of what it is that we're looking at, that we're dealing with at this particular hearing. My sense of it is that, and we need, of course, to get the exact detail, and I want to hear that from witnesses. Not today. That's going to happen at our next meeting, which is going to be on December 22nd. But what we need to do is to understand what the allegations are. So we do know from the information we have received so far that the voter had been a regular voter in St. Joseph County for many years and had voted in many elections, and that she did have a couple of changes of address. We do know that her voter registration was canceled which means that it was put into an official a status called canceled, because she did not respond to a request in early 2022 to provide additional information. And I think it had to do with either the last 4 digits of her social security number or her driver's license number. And then that, I believe that the allegations are that Amanda took a call from her, and then based on what she saw in the record, changed the status from a inactive status, or from a canceled status to an active status. And that on the 7th, which was not Election Day, which was the day before, that the voter submitted a ballot that was then held and then considered later by us, and then finally rejected at the last meeting, which was the November 18th meeting. So what we're looking at is whether the process, the procedure, was in fact followed appropriately, and if so, what the consequences are for that. So, Tom, is that a fair statement of where we are on that from your perspective?
Yeah, I think so. I think the only other thing to amplify the record is at that November 7th meeting, we did have some discussion about how we were going to proceed, procedural discussion about how we were going to move forward with a hearing. And I think it's fair to say on the eve of Election Day and with everything else going on, that there were probably some, not what we would call meetings of the mind, that we thought we had meetings of the mind and didn't, and that kind of caused me to move in one direction and then for us to kind of pull back on that in terms of moving it forward sooner than we had the opportunity to have this meeting.
So I think one of the issues has to do with subpoenas that were issued by Tom, and as we later discussed, and later as we had enough time to look, and again, this was the day before Election Day, look at the statute. Subpoenas may only be issued under the law by the election board itself, and then service of the subpoena, I believe, is to be by sheriff. I think, as I recall, that's the language in the statute is the following section. So my sense is that any subpoenas that were issued on that particular day by one election board members are not valid subpoenas, and they were not properly served. And I don't know why the statute says that the service needs to be done differently than what we're used to as attorneys, because many of those things can be served by others than the sheriff. So my sense is that, and I know there's one motion to quash, and I believe that was filed by Mr. Masters, who I don't think I see here today, who's the attorney for John Murphy, the auditor. I would make a motion that particular subpoena be quashed. And in response to that motion.
I already last time said I'm happy to just withdraw it.
Okay.
Based on the misunderstanding we had.
All right. Well, we'll consider that motion, or the subpoena, then withdrawn. And were there other subpoenas that you signed, Tom, and sent out?
I did sign one for the voter and hand-delivered it to her address, and she had a lockbox, mailbox, but I never heard anything back from her.
All right.
So I'm assuming since she didn't show up at that appointed time that she voluntarily quashed it herself.
All right. So, yeah, I'm assuming then that we will consider those subpoenas not as validly issued subpoenas.
Right.
And then we will determine whether or not we as a board want to issue subpoenas when we get to the end of this process. The other thing is that in order to make these hearings more efficient and to kind of bring in everything that we have, we don't need to follow formal rules of evidence, but we do need to make what we have available to the parties. There was a discussion that resulted in the set of minutes of November 7th at the November 7th meeting. This is the day before election, and we were, again, handling a number of things. So I think that what is in those minutes, as well as the exchange of emails among us dealing with that particular issue, I think should become then part of the record of the case. What that does is it shows what the concern is with the this particular issue, and it shows in part the positions that we have held, mostly myself and Mr. Dixon, on that issue. So I would then, unless there's objection, I'll just determine that we take judicial notice of all of those parts of the record and include those within the record.
That's fine with me. I'd move for that.
All right, so we have a motion to that effect. The second?
Second.
Okay, all in favor?
Aye.
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 Okay, so the various, the minutes of the November 7th meeting, in particular as it relates to this particular matter, and the thread of emails as it relates to this matter all become part of the record in this case. And I would presume that includes the emails back and forth with John Murphy, because I know that there were some that
Sure.
kind of explained where he was on this process, because there was a call that came into the auditor's office and got sent along. All right, so the next,
Yeah, and if I can just add to that, we all shared all of those emails amongst ourselves.
We
as
did.
Sort of as an open communication for us to kind of wade through the issues, the procedural issues that we were trying to figure out.
If you can make sure that you give me all of them, I will compile them for the next.
all right. Yeah, I've saved everything, and I'm sure Tom has too, and we'll just make sure that we've captured everything to make that part of the record in this matter. Next has to do with the kind of the setting of the hearing for disposition of this matter, and we have a hearing date on our calendar that is December 22nd at 2 p.m., and I would suggest that we formally set this matter for disposition on that date, and I would entertain a motion to that effect.
Make a motion.
Okay, I would second.
I'm not going to second that.
Okay. All in favor indicate by the sign of aye. Aye.
Aye.
Okay, motion
Get
carries.
a second?
Yeah.
You seconded it? Okay. All opposed, nay?
Okay. So motion passes 2-1 to set this matter for disposition on December 22nd. And the next, of course, is issuance and service of subpoenas for the hearing on December 22nd. I think we, of course, need to have the principals here. Tricia is the one who initially brought this to Mr. Dixon's attention and made certain allegations. I think that she needs to be here to be able to testify. I think that Amanda needs to be here to testify as to from her perspective, what the process was. Anybody else?
Yeah. First of all, the voter, I think, needs to come in and testify as their communications and what the procedures that were followed. Secondly, Mr. Murphy indicated in his communications, which will be made part of the public record, that when he spoke with that voter, it was days ahead of the 7th. So we have not gotten a response from their office as to who forwarded the call upstairs, because that's part of the record, is that the call came from Mr. Murphy's office to Tricia, who fielded the call and then transferred it to Amanda. So we have to figure out how to send out a subpoena to whoever in that office engaged in that. Mr. Murphy indicated it was not him, and I would 100% of the time take him at his word. But obviously there is something there. There is some issue there with the call coming in and registering is coming from Mr. Murphy's office, and we have not received a response to that request informally. So we have to figure out a way to get that person in to find out how it was that this voter came to them and then was transferred up to voter registration.
Okay. My sense is that that's probably a non-issue as it relates to the core issue that we're trying to decide here. On the other hand, I don't even know how we would subpoena an office to produce something. We're not talking about producing a document or a particular person to testify. I don't know.
Well, then I'll just have to reissue my subpoena to Mr. Murphy and ask him what kind of diligence he took upon my request to find out who in his office actually spoke with the voter and then transferred the call up here. To be clear, so I can make my record, when the voter communicated with Tricia, she indicated her political party being a Democrat, and she indicated she was told that she was supposed to talk with the Democrat voter registration person. So clearly, if that stuff is true, those are issues that are relevant to the inquiry that we're supposed to be engaging in. And we can't just not go to the very first step of the inquiry where the communication was had that was then transferred up here.
Well, if you can determine a way to get that. I don't know that, and I would defer to counsel in terms of, so we have a situation in which someone in an office may have taken a phone call and referred someone out. We believe it's not Mr. Murphy because he recalls a call, but the call he recalls is prior, it's a few days prior. So the question is there a process that allows us to subpoena an office? I don't believe there is.
Tom, what is it that you want him to
We-
do? Bring
we-
documents with him at the December 22nd
No, we
meeting?
want the person who fielded the call. We know the call was fielded by Mr. Murphy's office because it came up here on voter ID to Tricia from Mr. Murphy's office, which was what initiated my initial subpoena to Mr. Murphy. Mr. Murphy then said he wasn't working in this office that day, and I asked him to then do an inquiry of his office to find out who fielded the call from the woman that transferred the call up from their office to Tricia. And since that inquiry has started, I've been met with nothing but obfuscation about how to find that person who made that inquiry. The inquiry came up from an elected Democrat Party office, and it came up with a specific instruction to talk to the Democrat voter registration person. And we're trying to figure out who did that, because there could be two people in this process who stepped well outside the bounds of the law and who are elected officials, and we want to find out who they are. We know who one of our targets is. It's Amanda. We know that. That's not been anything that's been hidden. Of our investigation. That's what it's called when you're doing an investigation. So we just need to find out who the other person is, and we've not gotten any cooperation from Mr. Murphy's office on that. And we've gotten well, how do you subpoena an office? I say you subpoena an office by subpoenaing the office and saying, you're responsible for finding the person who took this call, and they need to come here and tell us what their communications were about.
My sense is that you can't subpoena an entire organization and ask them to sort among their people who has done a particular thing. You can do that as it respects to, say, a 30B6 deposition, which attorneys know is relating to a particular matter and
Okay, then
that's
I'm
not
going
quite
to
the same as
move,
this.
if that's your position, Chuck, I'm going to move to be allowed to provide a 30B6 notice of deposition to the office for the person who was responsible for taking the call from the voter and transferring it up here. And if that means that we have to continue the hearing, then I'm going to move to do that. We need to get to the bottom of this. There could have been some violations of the law, and we need to get to the bottom of it rather than pushing it and getting it done before we know all of the facts.
I don't have any objection to a 30B6 deposition if in fact you want to take a deposition, but it's got to be done within the next couple of weeks.
And how are we going to get a signature certified before our hearing? For those of you who are lay people, after a deposition's taken, the deponent has up to 30 days after the deposition's taken, and they receive a transcript of it to read and review it and sign it or make changes to it. So we're cramming a hearing in ahead of time for and saying, let's have a deposition that will have no value for the hearing, no legal value for the hearing.
We can expedite that. This is a very narrow matter. It's a very narrow matter, and there's only a small thing to be considered. It has to do with who is the right person to talk to.
Okay.
To name.
And so to be clear, then do I need to make a motion that we need to second and vote in favor of to allow me to take a 30B6 deposition, or are we just allowing that?
Yeah, I think I need to do that formally, and I think that at the same time, we also need to say that that there will be a very reduced window for approval, for getting a transcript and approving the transcript as a result of that, so that we have it in time for the December 22nd hearing.
Okay.
Could you point to me where in the election code it says that you have the ability to do a deposition? Because the only thing I see is that you have subpoena power and service of process. That's 36527 and 36528.
We have the power to conduct hearings, which means we have the power to conduct discovery.
No, it does not. The code is very, very clear, Tom.
Well, let me hear, I know that Amanda has counsel here, perhaps we can hear from her counsel as well as on this particular issue, if there in fact is anything that you want to say about that. Either of you?
Chuck, can I clarify something?
Hang on just a minute, let me see, let's get this, then we'll come back.
Mr. Chair, I appreciate the opportunity to speak briefly on the issue.
Name and address, please.
Certainly. Name is Alex Bowman. I'm an attorney with the law firm of Krieg DeVault in Mishawaka, 4101 Edison Lakes Parkway, Suite 100, Mishawaka, Indiana, 46545. I believe the discussion that's been had briefly on the record is accurate, that the rules of civil procedure are simply, the strict application of them do not apply to this venue and the investigation being done by the board. That's the comment I offer.
Did you indicate that you're Amanda's attorney?
There is I have submitted a written appearance to the board this afternoon.
So you're giving an opinion on her behalf as to how we're not going to have a person come and testify on an issue that's critical to our investigation?
No.
That's not what he said.
No, I have
He can talk for himself.
Responding to a request of the chair on that particular issue as it pertains to investigation and testimony to be taken in this.
Okay, and can I ask you, did you also submit a retainer fee agreement?
How inappropriate.
Yes.
May
I
okay.
speak?
One at a time, please.
May I speak as well?
Sure.
My name is James Groves. I'm also appearing here for Amanda. I'd like to comment on a couple things. First of all, to my knowledge, nothing in these codes applies the civil rules of procedure. In the absence of that, the term subpoena simply means subpoena, nothing else. The civil rules do not apply regarding any depositions unless it's done by the agreement of the parties. An independent person does not have to appear before this board to give a deposition. The other comment I'd like to make is Mr. Dixon has suggested that there is some political chicanery involved in accepting the vote of this lady. He said the call came from a Democrat-elected office, being the auditor's office. So it appears that what Mr. Dixon is driving to here is to have a hearing continued off until this board is comprised of a majority of Republicans. Let me suggest to this board that an attorney has an obligation to follow the facts and the law and to present those without political motivation. So, Mr. Dixon, if it is your motivation to have this dumped into a Republican election board, then I would seriously question the ethics of that motivation.
And I'm going to respond to that because you're
Go
now
ahead.
attacking me personally and professionally, which I do not appreciate.
Professionally, I am.
You will find in our communications going back and forth when we were trying to schedule this issue that we were basically operating in the dark as to has this come up before and what do we need to do to address it. We had a meeting on November 7th where we all agreed that we would send subpoenas out on November 7th. There's only one person from the press who was attended at that meeting. Then it was Mr. Leone who changed his position and said, well, no, we don't have authority to do that. Let's go check with our election board experts downstate. One Republican, one Democrat. We are having a meeting with them December 12th, 13th, and 14th. My recommendation in those emails was, that sounds good to me. Let's go corner them and get their input into this since they deal with this all the time. The responses from Mr. Leone were clearly to do exactly the opposite of what you're suggesting I do, which is to get this thing done as soon as possible while the membership of the board is 2 Democrats and 1 Republican, including what was just voted on today, which is let's have the hearing and do the disposition this year. So if you're going to throw those darts at me, Jim, you better throw them at everybody. This is something that is a serious legal matter that needs investigation. And we are sitting here saying one person who's a critical member of this and part of this investigation, we're going to work as hard as we can not to have that person testify.
Can I get your commitment that you will not try to dump this into 2023? Because now you're saying you want to get it done this year. You've
I'll
suggested,
get it done
let me
when-
finish. You've suggested that you're going to have to continue it unless you get this deposition. And then you've even talked about how much time it takes for the court reporter to get the affirmation on the deposition. We all know as trial lawyers that can be expedited. And so I anticipate on Amanda's behalf that we're going to have a full hearing on this on December 22nd, and that the board will not kick this over at your request.
I think you only heard what you wanted to hear. What I
Perhaps.
talked about was the problem with the 30-day rule for depositions, to which Chuck responded, we can expedite that. I wasn't given an opportunity after that to say, okay, let's expedite that.
Well, then let's
Then it was
say
a
it.
matter of let's get Amanda's attorneys up here to give their opinion as to whether or not the rules of civil procedure apply. If Amanda's attorneys standing here now are saying, yes, we can agree to have this 30B6 deposition and have an expedited transcript and have expedited signature and have the hearing this year, I'm in favor of that.
Okay, then, Mr. Dixon, let me just say this. It's really up to the board, as far as we're concerned on behalf of Amanda. If you want to go ahead with a 30B6 deposition, we're not going to object to that.
Okay.
We want the ability to explain the little thing that happened here to allow a lady to vote that has now been metastasized into what appears to be a federal issue. And by the way, at this point in time, I think this lady the voter was disenfranchised and possibly in violation of federal law because this was a federal election that we were talking about. That's all I have to say. But go ahead and take the deposition. That's fine.
Thank you.
Okay, thank you, Mr. Groves.
So now I'm going
Mr.
to
Bowman.
move to have us take the 30B6 deposition as I had originally moved and have an expedited transcript, expedited signature so that we can have the deposition transcript available ahead of the hearing on December 22nd. And if we have to, if it's later, then I'll make myself available later in December so we can have the hearing.
And you will be the one who is going to take this and actually do the deposition, I presume?
As long as I'm doing it and this board is saying it's okay for me to do it, so we don't have the same kind of confusion we had on November 7th.
I have no problem with that because it's your allegation and effectively Tricia's allegation that in fact this is a matter that involves the auditor's office and some kind of political chicanery on the part of the auditor.
I never said that. That's Jim
That's-
Groves' words. All I
That's
said
what I'm
was that
hearing.
it came up through that office from a woman who said that she was told that she was supposed to speak with a Democrat voter registration person. And we want to find out, why would somebody tell her that when everybody up in voter registration is capable of doing the same work?
All right. Okay. So we have a motion then on the floor to go ahead and hold this deposition with the understanding that we will have it available at the date of the hearing, which is December 22nd, 2022. I am okay with that. I would second that. Do we have all in favor then indicate by the sign of aye?
Aye.
Aye?
Aye.
Okay. We will do that.
Do we know on a procedural matter if the auditor's office has an attorney who needs to be a part of this conversation?
I think Mr. Masters had appeared for,
Mr. Murphy?
I'm sorry, for Mr. Murphy, correct.
Right, but
I
I'm
don't know
not,
if he would represent the auditor's office as such.
What do you mean, Mr. Hammond?
Hammond's the auditor.
Mr. Hammond, right. So,
So
right, but,
I would suggest afterwards that you would talk to him
okay.
about that.
And I did want to respond to one other comment about the highly inappropriate. Everybody has been asking about retainer fees for everything related to every piece of the litigation that's been going on in this thing. So I think it's a fair question to find out if it's private party or if it's government money that's being used to fund the lawyers. That's all I'm trying to get at. That was the same question that was asked of me.
Let me answer it. We're doing it pro bono.
Okay, thank you.
But let me remind you, if this goes through, all the way through litigation, and she is found to be not responsible for any of this, she's entitled to have the county pay her legal fees. But for right now, we're doing it for free, pro bono.
Thank you.
Thank you, Mr. Dwarfs.
You prefer to have the deposition at your office, Jim?
I think that's something you take up with Jim Masters,
Okay.
isn't it?
I believe so. All right, so we're still on the item of issuance and service of subpoenas for the hearing. I think that, certainly, Christie, do you have a point to make?
I do have a point to make. The complaint did not initially come from me. I want to clarify that. There is another individual who was listening to a conversation between Amanda and myself, and that is where the complaint started. It then went to my chair, Tyler Gillian, and then it escalated there. It was never initiated by me. I want to clarify that.
You're implying that there are others that have been part of this problem, including Tyler Gillian, who is?
Who is my boss? Yes.
And he is the chair of?
The Republican Party.
So I guess.
So you're suggesting, though, that he is an additional person who will have knowledge with respect to how this process went?
Yes, because he was notified by one of the deputies that overheard the conversation between Amanda and I, and she is the one who took concern with it, and it went from there.
So let me just speak for just a second, Chuck. Hold on just a second, because I think we're getting too far ahead of ourselves when we're talking about a complaint. I don't know that there's a written complaint. What happened was at the November 7th meeting is that I became aware of the allegations and I raised them in our meeting, and we decided we were going to have a hearing. So I don't know that there is any kind of official complaint that's been lodged by anybody, only the passing of information on and a decision to have a hearing.
Well, I mean, if we're going to investigate the auditor's office for how they passed this on based on a political decision, I think that we need to take a look at the whole way in which this proceeded. And if in fact there were specific instructions from Mr. Gilliam, then
Well,
we need to know that.
the reason it was brought forth is because the conversation that Amanda and I had was in front of the Republican deputy whose husband was the opponent of Mr. Murphy. This is why it's here.
Okay, so let's not get into the testimony at this point. I do think, yeah, so let's go ahead, and we do want to make sure that we have certain people here. I think you're a critical person. You know a lot of what has happened. Of course, Amanda. Mr. Dixon thinks we ought to have the voter herself here. I don't know that she wasn't responsive to your first subpoena. I'm not adverse to hearing from her as to kind of where, what her understanding was of the process going forward. And
Miss Upchurch as well. She was the one who was privy to the conversation.
Okay, to which conversation? In that office. All right. Yes, Jerry.
Since I'll probably be the one issuing the subpoenas, I'll need the voter's name and address.
Yes, we can
Okay.
provide.
Okay.
Provide that.
Everybody else
Mhm.
is going to their work addresses, or where do you want the subpoenas issued?
I mean,
I think-
people can accept subpoenas, you know, on the record. They can accept them at their work address if they want to.
I think work address is fine.
Okay.
If they're not accepted, I believe that technically the sheriff has to serve them, is my understanding.
Okay,
So,
I'll make sure the sheriff serves them.
or if someone will voluntarily accept a subpoena, then I think that's not necessary. We just need to go ahead and document it.
36528 states that the sheriff of a county for a general election and the chief law enforcement officer of a municipality for the municipal election shall serve all processes issued by the county election board. So I will not accept mine unless it is issued appropriately.
All right, that's fine. We have that clear. All right, so we are going to subpoena Tricia, Amanda, the voter, whose name we'll provide to you, and Ms. Upchurch.
And potentially the person in the office on the 30B6.
Potentially that person as well.
Are you going to do Mr. Gillian also?
I didn't have any conversations with him, so I don't know. The only conversation I had with anybody was with Tricia right before the meeting.
I know, but Tricia did, I guess.
She just said he was the guy
Well,
responsible.
yeah, my understanding.
He was informed by my deputy, who is sitting right there, who says that she will be a part of it.
But he should be too.
Okay, well, let's not get any testimony. We're not taking testimony today. We're just trying to figure out who to have here on December 22nd, and we'll take it from there. I do think it appropriate, since we've heard that Mr. Gilliam is part of this, that we actually issue a subpoena to him as well. So we have 5 subpoenas then to go out and to be issued by this board. Do we have a motion that they be issued on behalf of the board?
So moved.
Second.
Okay. All in favor indicate by the sign of aye. Aye. Motion is approved unanimously. All right. And Terry will work with you and make sure we can get them all out and properly served too. All right. So those are the items that we have as it relates to this particular issue, setting it for hearing on December 22nd. Are there any other matters that we need to deal, any preliminary matters that we need to deal with here?
I just wanted to clarify that. You said 6, I think, but there's
Oh.
the potential 7th with the 30B6 after we
All right.
hear that
That's it.
testimony. I mean,
That's it.
the testimony may be inane, and we may at the end of that just say, okay, thank you for your testimony, we don't need you here. But we may also, maybe the other way around.
All right, so that includes the additional individual, if in fact there is one from the auditor's office. All right. All right, and anything further as it relates to this particular matter?
Will the public have access to all the emails that Ms. Bland is going to?
They will become part of the record, and the record will be generally available as it is with all of our election board records.
Thank you, sir.
All right, thank you. All right, anything else on this matter? All right, let's move along. The next item on our agenda is action on the disclaimer violations. We had an earlier hearing in which we determined that there was non-compliance by the individuals. Names escape me. Mrs. Goebel, Hudnall, and Dobson, and also by Deborah Watts. These are slightly different situations. It appears that Deborah Watts, there was a sign that was placed by someone who she knew or knew her, but it was placed without her consent, and then I think she responded then at some point afterwards. So I guess the question is, now that we have already made a determination, are any of those individuals here today? Okay. I think it's appropriate if we in fact are going to determine whether or not we should issue any sort of a penalty as it relates to those disclaimer issues, given that we have found noncompliance, we need to give notice to the individuals involved. And I don't know that they have been notified that today is a day that we would consider that. So why don't we go ahead then and get notice out to those 4 individuals, and that we have determined, we've already made a determination of noncompliance, and the question is, what is the penalty, if any, that we will impose?
Do we want to, I mean, I've been fairly public about this with all 4 of them. I think all 4 of them tried to comply, and I don't think that we should, I think just finding that there was the noncompliance is enough for me. If we're not, if we're not going to ultimately decide as a board to do any kind of punishment, then why bring them in here for that purpose if you guys share my thoughts on that?
So yeah, and I appreciate that. My concern is that I don't know. I have been a member for 5 months. Tom's been a member for 2 months. Rita's a person here with some experience. But we don't really don't have a good, I don't have a good sense as to whether this is a first-time, one-off, innocent error, or whether in fact it's a part of a pattern.
Okay.
And, you know, for example, I went back and looked, before I came to this meeting, on the issues of, and we're going to talk about this later, filing campaign finance reports, filing them late or filing them defectively, and what happened last time around, which was in the spring. And there was a hearing, and there were a number of delinquencies and deficiencies that were dealt with. And at that time, fines were noted, but were all waived. And there were probably maybe 15 or so, is my recollection. So the question is, are any of those folks back now? I don't know. So I would like to take a look in our records and try to find out whether or not any of these individuals had been previously cited for campaign violations, because that would influence my decision as to whether or not this is a first time, perhaps an innocent error, or whether in fact it's part of a pattern of ignoring some of these rules that the state legislature has put in place.
I have a question for that. Was Tom making a motion to dismiss this because disclaimers were missing, because there were other candidates that didn't have disclaimers on their information either, that weren't probably brought to the attention of the board? But, so I'm just asking because it seems like we're wasting a lot of...
Yeah, I guess I'll make a motion that with regard to those 4 candidates who are the ones that we've been dealing with, that we recognize the delinquency and at this time move move it no further and have no sanction for them.
And you're suggesting we leave it at a finding of noncompliance, but then determine that there be no sanction at this point? Okay. I guess my question is, for either of you, do either of you have any information that these individuals have in fact had issues of noncompliance in the past?
I have not.
I don't, all I have, as you say, I've been here for 2 months, all I saw from all 4 of them was attempts to respond to us in a diligent way.
I mean, they made an attempt to correct their information. The law is gray. It doesn't give a specific size and point of what you have to do.
That's
It
true.
just says that you shall have disclaimers on your information.
And that they should be readable, or readable size.
Well, you can't even say that, because if you have signs, if you've ever seen, it just says that...
I've seen them.
Depends on the size of the
Understand.
sign.
Understand. All right, so you make a
That's
motion?
my motion, yeah.
Okay.
You want to second it, Rita?
I'm sorry?
Did you want to second my motion to confirm the finding of noncompliance, but to make a determination of no sanction?
I do. I mean, we're
All right.
wasting a lot of time over...
Okay, we have a motion and a second. All in favor indicate by the sign of aye.
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 Opposed? Nay. Motion carries. All right. So that issue is resolved. All right. Next item is an update on the remedial action taken on campaign finance deficiency, or deficient and delinquent filings. And there were there are 15 committees of various sorts that either filed delinquent campaign finance petitions or defective reports. Some of them were, in fact, cured in that the defective reports had listed expenses and inappropriately. I think there was a question around in-kind contributions and how they're treated for accounting purposes. So I did look at the, again, I think as I mentioned earlier, I did look at the minutes from, I believe it was earlier this year when Catherine Fennell was still in charge, or still the chair of the election board. There was a finding made by the board that as to what the fine would be if in fact it were imposed. And the fines ranged from, I believe, $50 to about $1,000. Some were fairly substantial. And then I believe on the motion of one of the members at the end, the fines were all deemed to be waived. Again, my only concern is that whether or not there are patterns here that in fact individuals or candidates are in fact kind of consistently or more often than once, having been warned perhaps 6 months ago, have once again elected to not get things done on time. And so my sense is that that is something that I would like to know as it relates to these individuals, or these particular committees, I should say, and as to whether or not we need to take any action based on that. So what I would ask for the clerk's office to do between now, and I think we can deal with this also on December 22nd, and I'll see if the other board members are okay with this, is to give us a report, and hopefully do that within the next week, as to whether or not any of these who in fact are either delinquent or have a defective report are repeat. There's a repeat of allegations of having problems. And then those are the ones that I would suggest that we consider. I'm not particularly concerned with those who, for the first time around, were a little bit late or perhaps, in fact, needed to sharpen their pencils and get their reports done correctly.
Chuck, are you talking about just from the primary and the general?
Just in the primary and the general.
Primary for this election.
For this, yes, just for this election. And if you could get us that within a week, I think that would be very helpful to us. Does that sound like a fair way to do that?
Yeah.
All right. I don't think we need a motion to that effect, but once we have that information, we will then go ahead and set this matter over of the delinquent or deficient reports, these 15, over to the December 22nd meeting. All right, at this point, is there any other business that needs to come before the board today?
Just as points of clarification, so that we're not repeating what happened after the November 7th, Terry, you indicated that you can get subpoenas out. Do you have subpoena forms? Okay, so you can get those and subpoena everybody for the 2 o'clock hearing. Okay, let's make sure that we procedurally have a separation of witnesses in place for that hearing. And then do my other board members need to see an advance copy of a 30B6 notice of deposition, or do you just trust that I can use one that I've used?
I think if it's a standard format, I think it's fine. But why don't you send us a copy? Send us a copy.
Okay. All right, thank you.
All right. This is the time for public comment. If anyone in the, that is here otherwise has a comment, please limit your statements to 3 minutes or less. And give us your name and address.
My name is Pat Schaefer, and I live in South Bend. And I had a printout of the election results. And as I'm filing through there and looking at it, I get down to Union Township. And the Republican election board member and voter registration was on the ballot, which means she should not be anywhere near absentee voting, anywhere near central count, anywhere near the provisional ballots that were opened that day. And also, she's the holder of the Republican key for the ballot door. And I have seen her down there at that door on a couple of occasions. And I think that is something that needs to be addressed by the board also. That is a state election law, that any candidate cannot be close to anything to do with the election. Can't work on election day or anything. So that is something that you need to look into too. Thank you.
Okay, and again, the name of the candidate, please.
The name of the candidate is Tricia Carrico.
Okay, thank you. Okay, well, we have received that complaint, and then let's we'll start the process of trying to learn what we can about it. But thank you for your comments.
She was there a lot in absentee voting.
Okay, thank you. All right. Yes.
Good afternoon, Mike McManus, 51940 Lilac Road. Mr. Dixon, you seem a little agitated today.
Our alma mater got our butts kicked.
I wish you were as concerned about Ben Horvath and the horrible allegations that a couple of candidates ran on about this alleged Keygate during the election, smearing our hardworking 30-year clerk. But let me get to my point. You, the Republican Party of St. Joseph County, and the Republican Party of Indiana have already filed a frivolous lawsuit against the Democratic clerk of my county and the Democratic chairman of the election board of my county. I believe, having looked carefully at the allegations of the lawsuit and having reviewed the rules of court, rules of professional conduct, that lawsuit violates a number of ethical provisions. And I think that you and the political statements you have made today, I don't need it, are clear enough that you should recuse yourself immediately. This has become a Republican witch hunt. And to hear, I was a deputy election commissioner. I didn't know that Ms. Carrico, for anybody that doesn't know, Patricia Carrico is sitting right there to Mr. Dixon's immediate
It's Tricia
left.
Carrico, not Patricia. Thank
Tricia
you.
Carrico. Thank you for clarifying that. To hear that she was and I saw her all over this building on election day. None of you should be anywhere near these frivolous allegations about a vote that didn't even count.
Thank you, Mr. McManus. Are there any other comments? Yes, sir.
I don't know. I still works, so.
That's fine, go ahead, shut it off. They'll hear me.
We have to record, so it's.
That's fine. You ready? Yeah. Scott Carrico, 18882 Pierce Road, Lakeville, Indiana. I'm here to talk about the fact that this, as you call witch hunt, there's a right and wrong. And from what I'm seeing, this is a part of exploring what is right and what is wrong. And let it come out to what it's going to be, whether it is frivolous or not, it still needs to be heard. Irregardless of the fact that she had a key that she did not want, and that she had to be down there under camera, away from the doorway on the opposite side.
She was down there by the door.
She was down by the door because she had to have a key. By the party.
Only one
Secondly,
person, only one person talking at a time.
under the camera and review the footage of it, where she never went in. Uncontested position in Union Township. Now, I understand that it is a delicate situation, and there is a right and wrong. Given the fact that she was put in the position to have to do that bipartisan is what she had to do. And anything else is just an attack on her character. That's all.
Thank you, sir. Do we have other comments?
Ryan Conrad, live in 1015 College Street. First, I'd like to say, Mr. Carrico, if you've got something to say to me, you could talk to me.
I'm not talking to you.
That's not what our comments are
You're supposed to
for.
address, y'all supposed to address the
Make
board.
your
please.
comments to us.
Absolutely. That's all I have. We'll have fun with this woodchuck, I'm sure.
Great, thank you. Are there any other comments? All right, seeing none, our next meeting date is December 22, 2022, at 2 p.m. in these chambers. Do we have a motion to adjourn?
So moved.
Second.
Okay, all in favor indicate by the sign of aye.
Aye.
We are adjourned. Thank you, everybody.
Are we gonna what? Yep. This is what they've done. We did, I gave them this already. If we've got time, we can have. I didn't say you could go home. I am not the boss. You have to ask her.
Hey, are we off the record?
I think we're off the record.